is first a brief introduction of the PTAB practice and why they are so popular. I know James talked a little bit about this yesterday, so I won't try to, hopefully I won't cover too much of it, but some of you who weren't here yesterday, it'll be some new information. For those of you that were here yesterday, it'll be a little bit of a refresher. I'll also talk a little bit more about claim construction in PTAB proceedings, because that ultimately is one of the biggest factors in IPRs and PGRs that we've encountered. Then we'll talk about some of the practical effects. What are the effects of PTAB proceedings on U.S. patent strategy and practice? To give you an idea of what these proceedings and essentially their effectiveness has done to U.S. patent practice. So I think James had a similar chart yesterday about differences, different types of PTAB proceedings. These were all, as I mentioned earlier, the result of the America Invents Act. This is a very detailed chart. I won't go over every single cell here, but a couple of the key differences that you'll see when they can be filed is a key difference. Difference between IPRs and PGRs is whether it's within 9 months of grant or after 9 months of grant. The covered business method patent challenge is more of a transitional challenge. It started off, you could file those starting in September of 2012, and you'll be able to file those until 2020, the year 2020. And that's when PGRs will kind of kick in full effect. We're starting to see PGRs. PGRs, as you can see, they only apply to patents that were filed after March of 2013 under the new first inventor to file regime. So we're just starting to see the patents come out that were filed after that date, and we're starting to see more and more post-grant reviews, PGRs. So this is all very exciting for us, that for those of us that practice in patent law in the U.S., because these are new proceedings, new procedures. We're learning on the fly as we conduct many of these proceedings, especially for things like PGR, which there haven't been that many. The grounds for what you can raise, the issues you can raise under the various challenges. I'll just point out that under IPR, all you can raise are 102 and 103 challenges using printed publications and patents. But in PGR and CBM, you can use prior use or prior sale. And you can also raise 112 issues, written description, enablement, things like that. I think James covered the estoppel effects. Honestly, before the new AIA kicked in and these procedures started to be used, there was some question. Most commentators, I think, most practitioners thought that this was likely going to be popular, but these proceedings, there were some drawbacks, and one of the big drawbacks was estoppel effect, in that if you use one of these tools here at the PTO, you won't be able to raise the same or reasonably could have raised issues in district court proceedings. And it was uncertain how parties and defendants and those accused of infringement of patents would see that limitation. Just a couple of notes about CBMs in particular. CBMs basically apply to patents that are not of a technological nature. You may ask, what does that mean? What does it mean to be not a technical invention? Well, the Patent Office has really construed that very broadly so far. The rules actually say it applies to patents that are, I'll read it actually, patents that claim a method or corresponding apparatus for performing data processing or other operations used in the practice, administration, or management of a financial product or service. But this does not include technological inventions. The Patent Office has construed financial product or service very broadly and to cover many things. For example, there have been cases where it was determined that a patent directed to advertising on smartphones was deemed to be a covered business method patent. A method of transmitting messages through servers, that was also considered a business method patent. But the limitation comes in when you start talking about what is technical. And basically, technical means it's not just a combination of known art and technologies. So that really is the key issue when it comes to arguing whether or not a patent is a covered business method patent. Some statistics, and this is thank you to Mr. Hannon and the USPTO. These are recent statistics about the filings of IPRs and CBMs and PGRs. As you can see, it's growing very fast through the fiscal year 2015, which I believe goes till October 1st of each year. The number of filings for IPRs has already exceeded the total number of IPRs filed in 2014. So you can see that this is, it's a very popular proceeding, and there are a lot of people who are using it. IPR proceedings and PGR proceedings and CBM proceedings go relatively quickly. When you compare this to the timeline of a typical district court litigation, this timeline of basically from filing petition to final written decision within 18 months is very fast for the U.S. I believe James probably mentioned how slowly patent cases can move in district court litigation in the U.S. Some courts are quick, but the most of them, your case is going to take more than 2 years. But in the PTO, in these PTAB proceedings, you can have a final decision within 18 months. And what we've seen is actually the PTO has done a really good job of actually instituting in many cases, especially in arts that are not as popular, well before the 6-month time period for institution decisions. You'll notice here that there's mention of discovery in PTAB proceedings. When I speak with my clients here in Taiwan, when I mention the word discovery, that is usually when I get a lot of moans and groans and thoughts of, oh my God, it's going to be expensive and I'm going to have to waste a lot of time on this. Well, at least for now, in our experience in the cases that we've done in the PTAB proceedings, discovery is very limited in these proceedings. Essentially, the board has a lot of leeway to allow or disallow discovery, and for the most part, what you're going to get is basically discovery on things that are cited in declarations or what experts talk about, things like that. You're not going to get broad discovery like you do in district court cases, and the standard for ordering discovery at the PTAB is much, much higher. You really have to show that there is a need for this information in this case. It's not just the typical relevant standard that you see in district courts. I was looking through the slides from yesterday that James presented, and no, I did not copy this from him. I think this was almost exactly like the slide that he had. But I just want to mention, when you look at the comparison between PGRs and PTAB proceedings with district court proceedings, basically everything here almost is in the patent challenger's advantage. You have a lower burden of proof. You don't have a presumption of validity. Claim construction is the broadest reasonable interpretation, which means that brings in more prior art. And we'll talk a little bit about that standard in the following slides. And the decision maker is a patent trial and appeal board judge who usually have backgrounds or relevant backgrounds in the technology area. As many of you know, when you have someone who knows the technology, they're going to be less likely to be impressed by technical terms and highly technical descriptions and patents. Okay. These are statistics that our firm actually keeps, and these can actually be found if you're interested on our AIA blog, aiablog.com. But basically, what these show is how effective or how powerful PTAB proceedings have been so far in the United States. These are statistics that only show cases that have gone through final decision, gone up to final decision. You'll see that almost 88% of the cases had at least some claims canceled. So when you're a patentee and you're a patent owner looking at this statistic, when an IPR against your patent gets instituted, your chances of surviving that unscathed is very low. We get a little bit more into the details here with this chart. This is actually an analysis, and we keep track of actually claim by claim what happens in decisions. As you can see here, once instituted, about 75% of all claims are actually canceled in IPRs. The one bright spot, somewhat bright spot, I guess you could say, for patent holders is these are all after institution. It turns out, statistically speaking, at least percentage-wise, you have a better chance of having the IPR not being instituted against your patent. In 2014, I believe it was about a 75% institution rate. So every petition that gets filed, 75% of them get instituted, and then you run into this buzzsaw statistic here. But in fiscal year 2015 so far, according to the USPTO records, the institution rate has dropped to about 69%. So a lot of the times when we work on IPRs on the defense side, if we're working for the patent owner, one of the biggest things we do is we spend time on the initial response, because that's sometimes your best chance of surviving the IPR, at least statistically. Cbm statistics are look even more intimidating for patent owners. Obviously, there aren't as many CBMs that have been filed and instituted, but when they are instituted, you can see that 95% essentially of those cases have all claims canceled. I'm sorry, 95% of claims instituted are canceled, and only 3.5% of claims actually survive a CBM. Okay, so if you're a patent owner, you see those statistics, you're concerned about your patent if someone challenges it. But if you're a defendant in a case, or if someone's asserting a patent against you or asking you to license their patents, those are very powerful statistics, and that you look at that and you say, that could be a tool that I can use to get some leverage in negotiations or licensing. So here are just a few of the benefits and why people are filing IPRs and CBMs. We've talked about most of these already, but we'll talk a little bit more about staying litigation in the slides that follow. Okay. So next I want to talk a little bit about claim construction in PTAB proceedings. In the earlier sessions today, Mr. Hannon and Judge Chen talked about the standards for obviousness. And I know that yesterday James talked about claim construction generally, and also including claim construction in PTAB proceedings. So some of this, again, I apologize if it's a little bit repetitive of what James said, but The standard in PTAB proceedings is a standard that essentially supposedly gets you a broader interpretation